All rise, please. Eddie. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Can you tell that we have a very happy Eagles fan as our court officer this morning? There's the most energy I've seen him with. Congratulations to your team. The wrong team, but it's okay. Good morning, everybody, and welcome to the Appeals Court. My name is Amy Blake. Joining me today on our panel is Justice William Meade and Justice Marguerite Grant. We are your panel for the 6 cases that are on the list today. I know that most of you have been here before, but as a reminder, each side is permitted 15 minutes of argument. There is no rebuttal. The one exception today is we have a paired case at the end of the list, and that case has a specific scheduling order. I can assure you that we have read all your materials, so you should get right to your arguments. With that, we will call our first case, COMMONWEALTH versus ALEXIS Gonzalez, docket number 24P 473. Good morning, counsel.
Good morning, Your Honor, and may it please the court, Joseph Hasson for the defendant appellant. We have 3 issues today for the court's consideration, so I'll start with the first one. As the court knows, usually a Crawford-type situation involves police interrogation, and the case law says, well, what's the officer's primary purpose in asking questions? And by that primary purpose, we will determine whether or not the responses are testimonial or they're not testimonial. The case we have today, there was no interrogation. It was just a phone call where the woman picked up the phone, the victim, and said, you know, I've been stabbed, you need to pick your son up. And that was it. That's the Commonwealth's case. And there was a motion in limine filed and heard, and the court found that it qualified as an excited utterance. And the court properly used the primary purpose test. But again, there was no interrogation here. And so, as the courts have said, the primary purpose test is an objective test. What a reasonable person in the declarant's situation would anticipate as to whether or not something that he or she said would end up in court used against the defendant.
Why isn't what she said on the phone evidence of an ongoing emergency? She was reporting that she had just been stabbed, right? Right.
Well, you know, she told the woman, don't call the police. Don't, I mean, even when the woman arrived, Miss Mercia, who eventually was the Commonwealth's witness.
Classic domestic violence response, right?
This is a domestic violence case. Yeah. Yes, it was. But again, like many cases where there's other evidence to convict a defendant, this was the whole schmear. If the jury didn't believe what Miss Mercia said, then it's...
Isn't the fact that she told her friend not to involve the police indicative of there not being a purpose to that what she says would result in a prosecution?
Well, again, you know, as I said in my brief, I believe the judge in deciding the case uses the subjective part of the test where he should have used the objective part, which is what would a reasonable person in the declarant's situation would have realized. And I'm saying she realized that this could be used at trial, and that's why she said, don't call the police. And when the woman arrived at the scene to pick the child up, again, she was adamant, do not get the police involved. The woman had to do it, you know, of her own volition after waiting for a while because, as she said at trial, she was adamant that she didn't want to pursue this. Additionally...
And she didn't testify.
The victim did not testify, right? And which is, again, I'm assuming she was summoned to come to court, and she didn't appear in court, which to me, in my mind, is further evidence that if I go to court, I'm going to have to say what happened, I'm going to get this guy in trouble. That's why, in the beginning, I didn't want the police involved. So, again, as, if I could just have a second here. Just to quote what Justice Seifer said in Rand, the testimonial hearsay inquiry focuses on whether a reasonable declarant similarly situated, that is, excited by the stress of a startling event, which is exactly what we have here, would have had the capacity to appreciate the legal ramifications of her statement. And she cites U.S. v. Brito. That's exactly the point I'm trying to make, is that don't call the police. I know what's going to happen if you call the police. I'm going to have to go to court. I'm going to have to testify, and, bad things are going to happen. And so would a reasonable person in that situation believe that eventually they would end up in court by saying what they said? And that's why she says, don't call the police. I'll tell you, but I'm not going to tell the police what happened.
Well, if
Yes.
Judge Drexler found that the declarant's primary purpose was not to make a testimonial statement, how do we get beyond that?
Well,
How do we find differently? In Rand, there was a recording.
Well, again, as I said in the brief, he said her primary purpose. My understanding of the test, it's not a subjective, which would be her purpose. It was a reasonable person, as Justice Seifer said, a reasonable person in the situation that the declarant found himself or herself, that is, excited by the stress of a startling event. That's precisely what we have here. It's an objective test, is what Justice Seifer was trying to say in her concurrence. It's not, and what the judge said was, I find that her primary purpose, meaning the victim, her primary purpose is, it doesn't make it testimonial. And I'm saying we don't care what her purpose is. It's what a reasonable person in her situation would believe could happen. And that's the difference. And again, there's great prejudice here because their whole case is, that one witness coming to court and testifying that I was told he stabbed me, and that's it. How do you cross-examine that? You don't. You say, well, it's an excited utterance. There's an indicia of reliability with excited utterances. That's why there are exceptions to the hearsay rule. But still, when you have a situation where that's it,
Well, there's a
that's the
stab
whole
wound.
case. I'm sorry?
There was evidence of a stab wound.
Yes, there was, the police officer came to court and testified when he did arrive eventually, and he did see that she had a wound. I don't know if he was in a position to say it was a stab wound, but then he said he went out into the kitchen and found a knife with some blood on it, but it's a kitchen knife, and as was said on cross-examination, anybody could have touched the kitchen knife because it's a kitchen knife, and finding some blood on a kitchen knife isn't all that uncommon in a kitchen if you're cutting meat or something.
There were hospital records, too.
I'm sorry?
There were hospital records, too, that indicated it was a stab wound.
Yes. But still, even arguing that the stab wound could not be contradicted, the question is, was it done in self-defense? The kid was old enough he could have done it. Maybe the child. This was not his mother there. This woman was a substitute for his mother, taking his mother's place. Maybe he had some, ill feelings toward her because he saw her as taking his mom's place. Again, all speculation.
Was there any evidence of that whatsoever at trial?
No, but then that's the problem that you have when you can't cross-examine the complaining witness. What was your relationship with the little boy? Did he ever have problems with him? Did he ever talk back to you? That's all the fodder that...
If that were true, then no out-of-court statement would ever be admissible in court.
I'm sorry, Judge.
If that were true, no out-of-court statement would ever be admissible at trial.
I don't see your point.
You can't confront them if your out-of-court statement comes into evidence.
Oh, yeah, well, I get that. Out-of-court statements, right, if they're an exception to the hearsay rule, come in because they all have their indicia of reliability. But this is a special case where, as I argued in my second argument, that I don't believe it was an excited utterance. It had already happened when they got there. The defendant was seated on the sofa. He wasn't bothering anybody.
See, but your time frame is wrong. What came into evidence was the phone call.
Right.
Not things that occurred 20 to 25 minutes later.
I understand. Well, you could, again, as I said in my brief, she was able to make a phone call. If he didn't want her, he could have stopped her from making a phone call. He could have cut the phone lines, as some people do. There's a lot of things he could have done, okay, to thwart her from calling, from, excuse me, making a phone call.
But he again, there's no evidence of any of that. And what there is evidence is her being excited during the phone call because she's just been stabbed.
Well, yes and no. Again, she was able to make a phone call, and she was able to tell her on the phone, don't call the police. So she did have, as I said in my brief, somewhat of a presence of mind. I mean, the hallmark of excited utterance is that you're so excited and so emotionally upset that you can't think and you just blurt stuff out. This woman wasn't blurting stuff out. She was able to think, get the child, get him out of here, I have a stab wound, don't call the police. Who's thinking about not calling the police? That's the first thing that she thought of. Clearly, she's able to think. The fact that she's crying, yeah, of course she's crying, she's just been stabbed. But she did have the presence of mind to tell her, whatever you do, don't call the police. So, I'll get to my third argument, if I kind of covered the second one. The prosecutor in her closing argument said there were a number of people who could have testified today but didn't. Well, who were they? She said, and you heard from two. Well, two, and then there's the victim, but she didn't say, and one other person. If her argument was, there's one other person that you could have heard from today to tell you what happened, you could have, but she's not here today. But that's not what she said. What the prosecutor said is there are a number of people who could have testified today, but they didn't. Well, the only people left to testify would have been the defendant, because her statement was made in the plural. And so, in my mind, she's saying, well, the defendant could have got up here and he could have told you what happened, but he didn't. I don't think what she did was intentional. I just think her wording was not as precise as I believe it should have been.
Well, it has to be intentional. It has to be naturally and necessarily a comment on the defendant not testifying.
Right. You can't comment on it. Well,
The defense opened and closed with the victim isn't here to tell you what happened. And then the Commonwealth says there are other people that can tell you what happened, and then she enumerates them, Mercia and then the police officer. It's in stark contrast to what happened in Griffin versus California, the seminal case where this came from. Do you remember what happened in that case?
not off the top of my head.
So Mr. Griffin murdered S.E. May. I don't think her last name is identified in the opinion. And in closing, the prosecutor said, only the defendant would know how she was killed, and he has not seen fit to take the stand and deny or explain. In the whole world, if anyone would know, defendant would know. S.E. May is dead, she can't tell you, and the defendant won't.
Right.
So that's necessarily
yes,
a comment on yes.
That's textbook.
Right. So not vague references that are explained by the prosecutor are necessarily and naturally a comment on the defendant not testifying.
Well, I'm just saying by the process of elimination, when you say other people could have testified, well, what other people could have testified?
What about the children?
Again, I don't know how old the child was, if they would have testimonial capacity. It was a small child. And they could have called the child as a witness if they thought the child was able to. But the child was in another room playing games. So based on what I understand the facts to be, the child would not have seen the actual incident between his father and the victim. There's no other questions from the court? I will submit on my brief.
I don't see any. Thank you, counsel.
All right, thank you.
Mr. O'Sullivan?
Good morning, and may it please the court. David O'Sullivan for the Commonwealth. I'll presume not that the court agrees, but that the court fully understands the Commonwealth's position as to all these issues, so I'll be brief unless there are questions. First of all, I would agree with my brother that the standard for testimonial statements is an objective one, but it looks not, as my brother contends, at what a reasonable declarant would believe, or under the old Gonzalez framework, what a reasonable declarant would anticipate. Instead, after Ohio v. Clark and Michigan v. Bryant shifted to the primary purpose of the person's, of the declarant. And when you consider, and we're arguing opposite propositions from the same fact in this case, we are both pointing to the fact of the victim's desire not to have police involved. And he's arguing that showed a reasonable anticipation on her part that this could be used prosecutorially against her. Well, under that old framework, that's a better argument than it is under the primary purpose test, because under the primary purpose test, it shows precisely the opposite. It shows that her purpose in rendering the statement was not to offer a substitute for trial testimony, not to bear testimony, not to offer an out-of-court equivalent, but rather to tell a friend that she had an ongoing emergency that required her help. She told only so much as was necessary to get her to come back to the house from work to pick up the children. She did so not formally. It was nothing like a retrospective, detailed recounting of what occurred. Rather, it was only so much information as would be necessary to get Marcia to come back to the house. She asked her not to call the police, and she ultimately, as the court pointed out, declined to participate in the prosecution. All those facts point to her primary purpose not being to bear testimony, but quite the opposite.
Counsel, do you agree with opposing counsel that the judge erred in framing the test as a subjective one of the declarant's primary purpose as opposed to an objective one?
I would agree that the test is objective. I would disagree that the judge improperly framed the test. I think by referencing the primary purpose test, the judge correctly identified the rubric under which we're arguing. That's an objective rubric. It looks to whether what purpose an objective observer would ascribe to the statement. But even if you were to say the judge erred by looking at his particular language, it's clear that the court can affirm for any reason that's apparent on the record. And looking at this question objectively, I would submit that the primary purpose that a reasonable person would ascribe to this was not to bear testimony, not to offer an out-of-court substitute for trial testimony. Now, with respect to the excited utterance issue, I think the judge was well within his discretion for many of the same reasons to find this fell within that exception to the hearsay rule. So if there are no questions on that, I'd move to the last issue. Now, what is forbidden is direct comment on a defendant's decision not to testify. Of course, the Commonwealth can emphasize the strong points of his case, even where doing so might cause the jury to have some passing or collateral reflection on the fact that the defendant chose not to testify. But again, what's forbidden is direct comment. And as this court has said, a prosecutor's statements are not prejudicially unfair if they are such a nature as such that the jury would infer that they, unless the jury would infer that they naturally and necessarily were directed toward the victim or the defendant's decision not to testify. And I would submit that just looking at the statements themselves, within the same sentence as the complained of portion, It's very clear that the prosecutor is referencing the point stressed in the defense closing argument, which was the victim's absence, not the defendant's
And
absence.
we're reviewing for substantial risk, right?
Correct, Your Honor. It was not objected to, which is a further indication that it was not reasonably viewed as directed toward that point. The victim, and I'm quoting from the closing, the victim is not the only person who can tell you what happened that night. There are a number of witnesses who can tell you what happened that night, and two of them did, because although the victim isn't here and didn't testify today, and again, I'd ask you not to speculate about the reasons why, you did hear from Ms. Murcia, and Ms. Murcia told you what the victim had told her. She then went on to properly summarize the testimony of Murcia and Officer Keogh. So I would submit there was no error, much less a substantial risk of a miscarriage of justice. If there are no further questions, I'd rest my brief.
I see none. Thank you both. The
Thank
case
you.
is under advisement. Our next case is Commonwealth versus Alexander DeJesus Dominguez Ortiz, docket number 24P67. Good morning.
Good morning, Your Honors. May it please the Court. Matthew Malm for the appellant. So the issue here is pretty straightforward. Is the parking lot attached to a retail establishment a public way, in the middle of the night when the retail establishment is closed, when there's a sign indicating that the parking is for customers only? So the question then, Your Honors, is that a public way?
But is that really the sole question? Because didn't he have to access a public way to get to the parking lot?
He did, Your Honor. So yes, so it is abutted by two public ways, but there's no direct evidence that he operated his vehicle under the influence while on those main roads, based on the evidence, which only...
After he crashed into the concrete and disabled the vehicle from operation, he decided that would be a good time to drink at 2:30 in the morning.
So the alternative theory would be that he pulled in sober to the parking lot, parked his car, became intoxicated,
And
then drove it.
Disabled it.
All within the parking lot, drove it within the parking lot.
Was there any evidence at trial of any of that?
So, well, the evidence did support that theory, Your Honor. And as I argue in my brief,
It supported the theory that he didn't drink until after he crashed the car?
no, until, so the alternative theory, and one, proposed by trial counsel, was that he parked his car, he drove to the parking lot sober, parked his car, either left, went and got intoxicated, came back, or got intoxicated while in the car, somehow got intoxicated after the car was within the confines of the parking lot, and then only operated his vehicle within that parking lot. So the evidence as it came in, which just showed him on top of the retaining wall that was inside that parking lot.
Well, this is a sufficiency claim, right?
So it is, yes. So the initial argument.
So we have to look at the evidence in the light most favorable to the Commonwealth.
Yeah, even in the light most favorable to the Commonwealth, that's equal and opposite inference. So I rely on that doctrine to show that there was insufficient evidence.
But you just told me there was no evidence to support the other theory. You're just trying to ask us to draw an inference. It's based on conjecture.
So in order to establish that he drove under the influence on a public road prior to entering that parking lot, that would require an inference, because no one observed him do that. So they'd have to infer that he was intoxicated. It was all one continuous event. He was intoxicated, drove from the main road into the parking lot, and then onto the retaining wall. Equally supported by the evidence is that he pulled into the parking lot sober, parked his car, became intoxicated at some point, and then only operated while intoxicated.
How many beer bottles were found in his car?
There was one beer bottle. And so I understand that the Commonwealth argues that so they're assuming that the theory was that he only drank in the car, but all the evidence equally supports an argument that he left the car, got intoxicated somewhere else, and came back to the car.
After parking it on the retaining
Parking it
wall?
while sober, yeah. So if your honors do accept my argument that it is a private way, then it comes to the question of what the resolution should be. Obviously, I argue that they're equal and opposite inferences, so insufficient evidence. It should be returned to the lower court and dismissed with prejudice. In the alternative, if your honors do believe that there is sufficient evidence to establish that, for a jury to find that he did operate under the influence on a public road prior, then it comes down to, then there's the real risk that the jury found him guilty of something that wasn't unlawful. Because they could have, based on how the evidence came in and based on what they knew of the law at trial, they could have found that, they could have said, oh, he only operated within the confines of the parking lot under intoxication, and still crashed, and base it on that. Which, if your honors find that that was not a public way, that's impossible. So he'd have been convicted on something that wasn't a crime.
I have a question for you about the sign. As I understand it, it says something like parking for name of the business,
Yeah.
customers and staff only.
Yes.
Does that mean the fact that people aren't, other than those categories, are not allowed to park there? Mm-hmm. Is that the same thing as saying members of the public don't have access?
Yeah, so I think so I'd address that first by talking about a case that's kind of similar. So Würzburger, which the Commonwealth cites, it's a case where there was a sign that specifically said no parking unless you have a permit. And that wasn't enough to establish that it was a private way. They said, oh, other cars can access it. Important in that case is that other cars, there was a clear purpose for accessing that area. There was a boat launch. So of course people can come in, launch their boats, and not even park. So there's an understanding, a reasonable person can see that and say, oh, there's a boat launch, I'm allowed to access that. That's a public way. Here, there's nothing else served by that parking lot. It wasn't a throughway to anywhere else. It's a house that housed the business on one side with a bright red sign on a white house, 7 spots, clearly delineated, retaining wall on one end of the row, sidewalk on the other, and then the one way, and then that fourth side was how they accessed. So there's no throughway. There's no reason for a person to be in that parking lot unless they're patronizing that business.
Well, but could I pull in and stop my car and respond to a text message from that parking lot? Because you're not supposed to text while driving, so I'm being a good citizen. What stops me from pulling into that parking lot to respond to a text?
So the fact that you can access that parking lot is irrelevant.
I don't know if the cases say that.
It's okay.
How about Hughes, Bellevue? There's a lot of cases
So
that
it's
say
not
that's relevant.
determinative. Sorry, it's not, access is not determinative. So Virgilio makes that perfectly clear. That's a driveway. It's a driveway shared by 2 apartment buildings. I think it was 2 cars wide. It did not have any barriers to access. So anybody, you could pull over there and check your text messages. And that was not, and they said that access does not mean it's public. It's a factor to consider. And I point to the case I mainly rely on for establishing that it wasn't a public way in KISS. There's no evidence of anything barring entry, and the court did not consider that at all. They said, oh, it's a shopping mall parking lot, middle of the night. The reason it's public is because it has some other amenities that are available.
That's where the ATM was,
Yeah.
right?
And the very same things that made it public are absent here. Otherwise the same. If there are no further questions, I'll rest on
I
my
don't
brief.
see any, counsel.
Okay.
Thank you so
Thank
much.
you.
Commonwealth?
Good morning. May it please the Court. Hallie White-Spade, Assistant District Attorney for Middlesex, on behalf of the Commonwealth. This case falls squarely within the parameters of the case law for public way. Just looking at the parking lot, there were no barriers to entry, as there were in Bellevue. There is no sign forbidding entry or through passage, as there was in Bellevue. Granted, this court in that case said it was a close question, but there was no need to address it because the defendant clearly had to drive on public ways to get to the pier there, parking lot here, and the reasoning is the same. I don't want to belabor the details of those cases. There was clearly enough to send this issue to the jury. Furthermore, I would just like to flag this issue of the equal and opposite inferences. This supposed doctrine that where the evidence supports two inconsistent propositions, one consistent with innocence, one's consistent with guilt, we have to give the defendant the benefit of the doubt. That's an analysis that takes place only after we've looked at the evidence all together and drawn all inferences in the light most favorable to the Commonwealth. And it's being deployed more and more often now as basically any time there's an inference inconsistent with guilt that is reasonable and possible, the evidence is necessarily insufficient, and that simply is not the law. We draw all inferences in favor of the Commonwealth. We do not balance evidence of guilt against evidence of innocence. We do not require the Commonwealth to disprove alternate theories of the offense. So I just wanted, and this court has at times said as much, and said as much in Commonwealth v. Romero a couple of years ago. It was Justice Meade's opinion.
Sometimes we've said a lot more.
And unfortunately, the SJC took that and reversed it and didn't include any of the great language about the equal and opposite inferences.
And rejected in every federal court. And it predates Jackson versus Virginia.
That is what the law is. And this court, this case is entirely consistent with Beliveau, Wurzburger, and all the cases on public way. And if the court has specific questions about this case, I'm happy to answer them. But otherwise, I'll rely on the brief and ask the court to affirm.
I don't see any. Thank you so
Thank
much.
you.
The case is under advisement. Our next case is Commonwealth versus Stephanie Fernandez, 24P732. As counsel approaches, I recognize that this is a highly emotional case. I expect everyone in the courtroom to comport themselves as I understand they did in the trial court. But what I would ask is, at the conclusion of the argument, counsel, if you would leave first with the parties that are here.
If I would leave?
If you will, after the end of the argument, I'm going to ask the Commonwealth to stay. And if you leave with your side of the case, wait about 5 or 10 minutes, and then I'll ask the Commonwealth to leave with their side of the case.
But I may listen to the conclusion of the
No. Everyone's going to argue. It's at the end of the
right.
case. I don't want there to be interaction between the families
I get you.
unnecessarily. That's all I'm trying to prevent, okay?
Thank you so much.
You're very welcome. When you're ready, please begin.
Yes. The refusal of the court to instruct on accident was prejudicial error. Everyone knows the rule that when there's any evidence of accident, an instruction must come forward. That's Commonwealth versus Campbell. And it doesn't matter whether the judge credits the evidence of accident or whether he doesn't. That's a jury question. That question occurs in Commonwealth versus Power Coat. In that case, the defendant shot the victim and said, "I didn't mean to pull the trigger." No instruction on accident, reversal of the manslaughter conviction. In this case, there was evidence of both self-defense and accident. In that respect, it would be similar to Commonwealth versus Zezima. In fact, Zezima is actually mentioned in the Commonwealth brief because in the case it mentions Pena, no evidence of accident. But the opinion in Pena says this is not like Zezima. Zezima thinks a man named Miller is going to rob him. Zezima pulls out a gun, self-defense. Miller reaches for the gun. There's a struggle. The gun goes off. Accident. In some cases, you get instructions on both accident and self-defense. And that was the situation in Ms. Fernandez' case.
Do you have a case where there was an accident on both, accident and self-defense, when there was an instruction?
Yes, that's Zezima, and I can...
And it was not a shooting case?
And it was not
It
what?
was not a gun, a shooting case?
You know, they're mostly guns. I can also mention Commonwealth, let's see, no, I can't. But in some cases, you require both. And actually, the one I meant was Commonwealth versus Turner, 24 Mass Appeals Court 902, instructions on both accident and self-defense. And that was the situation here. Ms. Fernandez says, look, Mr. Wagner attacked me in the parlor. I run to the kitchen. I pull up a knife and I say, don't come near me. He rushes her, grabs her throat, grabs her hand. She's frozen there in place, and the next thing she knows is he's saying, Stephanie, I think I was stabbed. It's confusion, it's quick. She doesn't know what happens.
Well, she went and got the knife after he attacked her, right?
Right,
And
but
held
he-
it and held
he
it
did-
and held it in front of her, and then he put his hands around her throat, and then he says he got stabbed. And she told the neighbors that he hit me and I hit him.
Yes, but that is not, stabbing someone is not hitting someone. Hitting someone is a fist. Stabbing someone in standard English is different. She says, at any rate, in her testimony, I was frozen, I didn't move, I had no intention. And you have to look at that in a light most favorable to the defendant. You can
What
disagree-
intent,
I'm sorry?
what intent does the Commonwealth have to prove for voluntary manslaughter?
It has to prove an intentional act that causes a homicide, a death.
Well, it can be reckless, though.
This was not a case where she was convicted of reckless homicide. She was convicted of voluntary homicide.
Involuntary manslaughter can be
Voluntary
reckless.
manslaughter, yes.
No? All right.
And just like the defendant in Power Coke, convicted. And in either case, an instruction was required. I can see the bench is giving me a lot of skepticism about whether this was in fact.
I'm just listening.
Maybe I misread the bench. It wouldn't be the first time. She was entitled to instruction because the Commonwealth had to prove the absence of accident. That's due process, and she was deprived of her right. Let me talk about the expert testimony in this case.
Before you get to that, what do you say to the cases the Commonwealth cites? I think Scalia is one of them that say that.
I'm sorry?
What do you say to the Commonwealth's argument that voluntary manslaughter and an accidental killing are mutually exclusive concepts?
It depends on the facts. And that's why that's why Pena cites Zezima. And Zezima is a whole string of similar cases, which when you shepherdize them, I only cite three: Barton, Zezima, and Turner. But I think they also cite Zagzima, something like that. It's in my brief. This is not something I'm making up. This is something that is black letter law.
One more question on accident. In your record appendix, there's the request for jury instructions by trial counsel. It's at page 67.
67 and 66.
Where did that instruction come from, that proposed language? It doesn't have a case.
Well, they cite several cases following the proposed instructions.
Okay.
including ZHENG. Moving on to the expert testimony. The expert violated the first three boundaries of expert testimony. You don't get to comment on credibility of the defendant. You don't get to create an abusive syndrome or profile and put the defendant in it. You don't get to talk about her personality as being a cause or a likely cause of crime.
Were these issues raised in the trial court?
I don't believe counsel raised them, and
So
they're
we're
bad.
reviewing for what? Substantial?
sorry?
We're reviewing for substantial risk?
Yes.
Okay.
First of all, you don't comment on credibility. Now, this expert could have said, look, I don't find that she has battered women syndrome. That would be legit. I tested her for anxiety, for startle reflex, that kind of stuff. That's not what he says. I say she, in fact, was not abused. Her story of being abused is false, in effect, and he says that over and over. My opinion is that she was not abused, she's not a legitimate victim, this is not a real case, and that was out of
Also,
bounds.
he claimed not to know what the truth is, and it wasn't his job to believe or not believe.
That was, I thought, a very sophisticated thing. He's saying, look, it's not a question of what I believe. I weigh the evidence.
He
And
said
the
in
evidence
his
turns out
40
she was not
he's-
abused. He didn't
in
withdraw
40
that opinion.
In his 45 years of experience, he's never seen a domestic violence victim behave like this when she taunts her supposed abuser.
Right. The question isn't whether she is an abuser. That's a syndrome. And just like Commonwealth versus Day, you don't say he's a batterer. He belongs to that syndrome. Batters women's system.
Didn't Dr. Ball say she was?
Sorry?
Didn't Dr. Ball, her expert witness, say that she was a domestic violence victim?
She said she had battered women's syndrome.
I'm sorry,
That's
but-
different than saying, I know that she was or was not battered.
So what about the fact that Dr. Ball said that she fit the personality profile of a battered woman? Is that a problem?
She didn't say she fits a personality profile of an abusive person or of an antisocial person. She's saying this is consistent, but it doesn't lead to any sort of bad behavior. What the Dr. Adams says is this leads to bad behavior. She's got this abusive problem. Commonwealth versus Day says you can't do that.
I'm confused because Adams says at transcript 12, defendant was, quote, not a victim of domestic violence and, quote, did not fit the profile or experience of a battered woman. Ball then says at transcript 11 and 12, quote, defendant meets all the criteria for battered women syndrome, that she, quote, experiences the symptoms of battered women syndrome, and that the defendant's relationship with the victim was, quote, a cycle of violence. Aren't those two sides of the same coin? In other words, if you have a problem with Adams' testimony, you should have a problem with Ball's testimony. It was a battle of the experts. The jury decided who they believed.
But they don't get to decide whether she fits a profile or syndrome. That is
But they
off.
both said it. I guess that's why I'm confused. And you backdrop that against the lack of an objection at trial.
Yeah. She's not giving an opinion about whether abuse is in fact happening. You can't do that.
But what then do we do with the language of Chapter 233, Section 23F, that talks about expert testimony as described in Clause A, which is evidence that the defendant is or has been the victim of acts or of physical, sexual, or psychological harm or abuse. Doesn't this statute specifically permit?
The defendant can put that in.
But the Commonwealth can't?
prosecution cannot, because if a prosecution puts it in, then it becomes a syndrome evidence. I realize my time is short
Doesn't
here.
the
I've only got
Commonwealth get
3
to
minutes.
rebut?
I'm sorry?
Once the defendant puts it in, are you saying the Commonwealth can't rebut it with their own evidence?
It can object, and it can move to strike, but it cannot poison the waters to this degree over and over.
And what case says that? Sorry, Justice Grant.
That is Commonwealth versus Day. They said that their expert said he fits the profile of an abuser. It's also Commonwealth versus Federico. He fits the profile of a sexual abuser. Finally, you can't put on the defendant's character as a cause for a crime. Fits of rage. The personal characteristics of the defendant are harped on, and they're harped on in closing argument. She's not telling the truth, says Mr. McLaughlin, the prosecutor. The doctor says she's got this profile, she's an abuser, but most of all, he uses fits of rage 6 times in the emotional climax of the argument.
Mr. Romer, Mr. Romer, those were in evidence, though. I know you're not happy with Dr. Adams' testimony, but he did testify.
But you can never argue bad character as evidence, and he had no reason, he had no legitimate reason for putting that in. She's being convicted because she allegedly has fits of rage.
I'm sorry. Will you agree, though, that your Dalbert-Lanigan challenge to Dr. Adams, raised for the first time on appeal, is waived?
It wasn't raised at trial, but the court can consider it to see whether there was.
Do you have a case that lets us do that for the first time on appeal? Because I've never seen one.
We'll find it. If I'd ask about the evidence. They put on, you lied, didn't you, in court when you pulled back this restraining order. Puts it in for 5 pages. Now, everyone knows you can't put in prior acts of unrelated dishonesty. You know that if you're an experienced prosecutor. You know that if you passed your evidence course in law school. But they harp on it, knowing it shouldn't be there. They put in prior bad acts with other men. The Commonwealth says, well, this is reverse adjutant. If you look at the transcript at volume 11-9, Mr. Ettenberg points out that there is no rebuttal because the defense never put in adjutant. And the judge never ruled that adjutant would be admissible.
Self-defense was in play, though, right?
I'm sorry?
Self-defense was raised.
Self-defense, but not defense, but there was no first aggressor.
That's part and parcel of self-defense.
Well, in that way, you'd have to say that the reverse adjutant rule just doesn't exist because the Commonwealth can put in any prior bad acts as long as you're claiming self-defense.
They can put in any act that shows that's probable that she was the first aggressor.
Yeah, you can do that if you do it with adjutant. You can't do it with third parties unless the defendant opens the door to that, and they didn't.
Justice Grant has an additional
One question. Are you asking us to rule that the SJC's model jury instructions on homicide are wrong?
No, this is perfectly consistent with them. An intentional touching is necessary to a homicide. And if the defendant says it wasn't intentional, she gets an instruction.
Thank you. Commonwealth? Counsel, you can sit at counsel table. Please feel free to sit at counsel table so you make sure we hear everything. Wherever you're most comfortable. You'd rather sit there, no problem.
Good morning. May it please the Court. Donna Marie Heron, Assistant District Attorney representing the Commonwealth. Just want to start today by acknowledging the victim's family in the courtroom today, the Wagners. I also want to clarify the record. The defendant was convicted of voluntary manslaughter, not of involuntary manslaughter.
Keep making that mistake.
Yes, that can be a tricky mistake to make. Starting to the first issue, the trial judge here, Judge Braden, properly declined to instruct the jury on accident where the evidence, even in viewed in light most favorable to the defendant, didn't warrant such an instruction.
Didn't the Commonwealth ask for or agree to the instruction?
That was me, and I always do that in abundance of caution.
Okay.
So we're not here arguing that the defendant is entitled to an accident instruction, so that's why.
But she would have been entitled to it for the murder charge.
She could have been, yes. That's what my thinking was going. Honestly, in an abundance of caution, so that we're not, because I did not see accident whatsoever. So my thinking, to be quite frank with you, was what harm could it do us, and I'm going to prevent an issue on appeal if I just agree to the accident instruction into that. But Judge Reardon, in reading his decision, I agreed to not abuse his discretion and follow the law. The testimony was from the defendant was that after the victim beat her up and try to rape her, she's running around, she grabs a knife, and she holds it out in front of her, and I think she testifies both hands in front of her. The defendant comes up to her, grabs her by the throat, and tells her to give him the knife, and then she doesn't know what happened, that she was confused, she froze, but she explicitly denies on cross-examination that he accidentally ran into the knife or fell into the knife. She says, that's not what I said. And also, Judge Reardon properly considered this with uncontroverted testimony from the ME that the wound was a downward, left to right thing. So in considering all that, even in light most favorable to the Commonwealth, Judge Reardon properly declined to give the accident instruction and properly said this is a self-defense case. This is what her defense is, that she ran and grabbed the knife in self-defense, and that's what I'm going to instruct the jury. And I would suggest that was a proper exercise of his discretion, and there was no error in failing to give the accident instruction. Moving on, if there's no further questions, to the second issue, the judge properly exercised his discretion to omit Dr. Adams' testimony regarding intimate partner violence, and his opinion that the victim, and not the defendant, was the victim of such violence was proper to rebut Dr. Ball's testimony, where Dr. Ball testified that it was her opinion that the victim met the criteria of a battered woman, that she gave her a test and she scored high on that, and also she then starts going over symptoms or classic signs of battered woman syndrome and testified how the defendant met each of those signs, and she gave specific examples like putting the gun in the mouth or other examples from her interview with the defendant and her view of the evidence. The Commonwealth was entitled and it was proper to allow the Commonwealth to call an expert to testify to their opinion based on the evidence that was in trial, that the victim was the victim of battered intimate partner violence and not the defendant.
I quoted some testimony to Brother Counsel, and I just want to ask you, so Adams says, quote, she did not fit the profile or the experience of a battered woman. Ball says, quote, she meets all the criteria for battered woman syndrome. Is that two sides of the same coin?
Yeah, I think they're both saying opposite, yes.
The opposite.
The opposite, but in their opinion, based on all the evidence in trial, which I think is a proper opinion. And this was without objection by the defense, and it was properly admitted. And
Adams had the police reports, the grand jury minutes, interviews, Ball's report, cell phones, and he did interviewing and testing of the defendant.
He did as well, yes, correct, Your Honor. And I do want to say, because I think there's something in the reply brief, all the cell phone evidence was admitted into evidence between the victim and the defendant. So while he says there were 17,000 text messages, that was admitted. We put it as an exhibit. We just highlighted, and the other side highlighted certain text messages between the two parties. But the whole download was admitted into evidence at trial. So if the jury so choose, they could have also have viewed those 17,000 text messages over the years between the victim and the defendant. So to the extent that when I read his reply brief, it sounded like that wasn't in evidence, that was in evidence. So everything that Dr. Adams testified to either was in evidence or there could have been in evidence, could have been properly admitted. And in fact, the car incident the Commonwealth was trying to get in and was prevented from getting into evidence when he was talking about the signs of someone who's in an intimate intimate partner violence situation, and he was giving specific examples of how he came to his opinion, which was control and fear. And he gave examples as to how he felt the victim met those criteria and that the defendant
So how do you respond to your brother's argument that he's allowed to put in that evidence under the statute, but you're not allowed to?
I cite to Commonwealth versus Ostrander, which is a 2004 case, which says is when the defendant puts battered woman syndrome into as a defense, the Commonwealth is entitled to rebut that defense with its own expert. And I just think that just how when you put your mental health at issue, the Commonwealth is allowed to present its own expert to rebut what the defendant's expert has stated. And the fact that our expert had 45 years, and I don't think there's any challenge to his criteria. And Justice Meade, I would suggest that under Wilkinson, you cannot, for the first time on appeal, make a Dahlberg-Landigan challenge to the basis of an expert's opinion, so that's waived, and I don't think this court should address that challenge that's made for the first time on appeal. If there's no further questions?
No, I have one. One of the preserved claims relates to the cross-examination of Ms. Lord, and the defendant says that the Commonwealth wrongly insinuated bad character based on her job. And you write in your brief that it was highly probative and relevant to her credibility. How does one's occupation as an exotic dancer go to her credibility?
Well, it's the fact that the fact that she was an exotic dancer was in evidence.
Oh, no, I agree, but I mean, it's not illegal.
No, it's not, but the fact that they use manipulation to get money and ties goes to state of mind. But even if this court finds that that wasn't a relevant thing, I would suggest it wasn't mentioning I wasn't mentioning closing at all. It was a brief testimony, and the only and the witness itself said, well, the defendant just started dancing. She wasn't a manipulator. She didn't use a stage name, so she specifically said that the defendant didn't use any of those.
The photographs.
Yes.
One of the things you say in your brief is that they're relevant to show that she was not a victim of domestic violence because they didn't depict any bruises.
Yes.
Was it in evidence that they were taken at a time relevant where she would have displayed bruises had she been?
Yes. So the defendant's testimony was that she was routinely abused by the victim throughout their relationship, beginning in 2009 at the strip club, when he beat her up. Throughout the whole relationship, she testified she was constantly getting beaten. So the Commonwealth, and I can tell that each of these pictures was testified to the date they were created. There was a lot of testimony regarding that. So each of these, so the Commonwealth put in a lot of photographs to show throughout the years she had no bruising, and there indeed was one very pertinent one as well, which was the July 4th party, which the defendant testified that she was beaten so bad that she passed out outside of her apartment with the victim, and that she had bruises everywhere, and the Commonwealth introduced a picture of July 6th of that same year with no bruises whatsoever on her body. So the Commonwealth, through these pictures, were able to show throughout the years that she did not have bruises, despite her testimony that she was routinely abused by the victim. And it was to show, in the Commonwealth's view, that she was lying when she said she was, or to disprove. It was used to disprove her defense.
Were all of these photographs in the text messages that she sent to the two gentlemen?
All these were downloaded from her cell phone and the victim's cell phone. And there was one where, again, she's claiming she's petrified of the victim, doesn't want anything, and she's sending the same naked picture to both him and her other fiance at the time, Mr. Laramie. So I'd suggest that's state of mind evidence to show that she really wasn't petrified of the victim. And indeed, it was relied on by both experts as well.
That's what Adam said too, right?
Yes,
Yeah. That
you wouldn't taunt your abuser the way she taunted Mr. Wagner. So I'd suggest that as Judge Braden properly found that they were relevant and they were probative. And he gave any prejudice was cured by his strong, and he gave it repeatedly, curative instructions as to how the jury could use all this evidence and how they could, how not to use it. If there's no further questions, the Commonwealth rests on its brief.
I don't see any further questions. Thank you. The
Thank you
matter
very
is
much.
under advisement. Thank you, Counsel Both. I'm going to ask the Commonwealth to stay in the courtroom. We are going to take the morning recess. When we return, we will start with the DCF case.
Court all rise, please. Court is now in session. Please be seated.
All right, we are back on the record. The next case is the Department of Children and Families versus Mother, docket 24P70. I know we have experienced counsel, but a reminder that this case is impounded, meaning no names, please. Attorney Eisenman, when you are ready.
Thank you very much. Good morning. May it please the court, Lynn Eisenman on behalf of Mother, who hopefully should be watching via the live stream. Your Honors, Mother is asking that you vacate the decree terminating her parental rights. This case is really only about the issue of termination. At trial, Mom acknowledged that she could not take custody of her son at that point because she was in a residential program, which did not allow him to live with her. So the only question remaining was, should her parental rights have been terminated at the time that they were? Certainly, Mother had a long history of substance use and unsuccessful attempts at recovery, and I think she acknowledged that during trial. And intertwined with that certainly was her mental health struggles. But by March of 2023, when this trial started, the switch seemed to have flipped and things were changing for her. So 2 key points. Mother was engaged in services by the time that trial started. She was at a program which she had entered as a result of being on probation, and certainly she was required to stay there so that she was not violated on probation. But nevertheless, she was complying with the requirements of the program, and those requirements were quite extensive. Things like full-time employment, the 12-step program, meeting with her clinician at the program, participating in groups at the program, doing chores, and staying substance-free. And it required a dedication from her that she was able to demonstrate, and yes, it had been about 6 months by the time that the judge issued her decree, but this was a real change for Mom from what she had demonstrated prior to that point. And we know from the testimony of the director from the program that this was a zero tolerance. So if Mom had one positive screen and she underwent screens, an extensive number of screens, she was going to be required to leave the program. So her screens were clean. Again, demonstrating that she was really committed to her treatment at this time. And the director of the program said this is a different mother this time around than she was 2 years prior.
One of the things that concerns me greatly in this case is the child's special needs, both educationally, cognitively, physically. He has a lot going on.
Yes.
Mom has a lot going on trying to maintain herself. What evidence do we have about her ability, because one of the things you raise is that it wasn't in the child's best interest to terminate. What is the best evidence that we have about her ability to meet this child's very significant special needs?
So she had been in contact with the early intervention worker, I think a couple of times. She had been allowed to contact the pediatrician's office. To answer your question directly, that she wasn't taking care of him on a daily basis to be able to demonstrate that. I think it's a bit of a struggle because she's trying to get herself right. What does she need to focus on? She's not going to be able to focus on everything.
Isn't that the exact dilemma that Judge Ahern was faced with?
Right, yes. So, and this is a struggle in a lot of these cases. So I think recently the courts have done a good job of recognizing that substance use treatment is not necessarily going to be linear. There's going to be ups and downs. They now have the family treatment court in juvenile court. Mom was engaged with drug court. So I think getting and focusing on her treatment first was where Mom needed to be. And giving her some more time to then demonstrate, once she was solid with that and had completed the program, her residential program that she was at, giving her some time when she went into the sober house to continue to demonstrate her progress, engage in more services, show that she had an understanding of the child's needs because they were extensive.
But she didn't make inquiry of the foster family as to the child's well-being, how to take care of him. In fact, there was little contact at all until the eve of trial.
Right. And Mom had not been in contact even with DCF until really the eve of trial. And that's why I say in that generally February to March timeframe is when things changed. And again, she was focusing on trying to get herself right first, because the hope being that everything else would then kind of flow from that.
Had she claimed that she was getting mental health treatment individually apart from DCF?
She did claim that, yes.
But she would not sign any releases.
Correct.
So there's a fair inference that that was not the truth.
That's a fair inference. Correct. I think the judge was entitled.
That's the one the judge drew.
Yes, I think the judge was entitled to make that finding. You know, from Mom's perspective, that's an erroneous finding, but I think the judge is entitled to do that. You know, that wasn't a requirement of the program itself for her to engage in individual therapy. You know, so I think the judge added that. I don't want to say the judge, but the department and the court added that as a task that they would like to see Mother participate in. But in and of itself, it wasn't something that the program was asking her to do, because that was not a dual diagnosis program. And she was ordered to be at that program as a condition of probation, so that's what she's left with.
Well, and to that point, at finding 268, and this is the conundrum that I think you have, the judge finds Mom was not in a position to have custody because she was unable to assume custody without leaving the program, and if she left, it would violate the terms of her probation, and she would likely be incarcerated. So
Correct.
What was the judge to do?
So I think this was a Carlos scenario, where let's give her 6 more months, because after that 6 more months, she told the judge on the day that the decree was issued that she had gotten accepted into a sober house. She was going, I think, the end of that week when the judge issued her decision. That was supposed to be, according to the director's testimony, that was going to be about 6 more months in the sober house. So let's see where she's at that point. And then everybody's going to know at that point she's either engaged in additional services, she knows what she needs to do, because she's been told by the decision of the court, or she doesn't. And at that point, they can reevaluate and see where she's at. And it wouldn't have added a significant amount of time to the case. The case was relatively new, even at trial. It was only, I think, when the judge issued her decree, 15 months old, which is not old at all in the life of these kinds of cases. So to give her 6 more months is not going to really significantly delay permanency one way or the other.
This child was born in June of 2022, and Mom's parental rights to the other child that's not the subject of this petition was 2 months before this child was born, correct?
I don't have the date off the top of my head when that
It was a short
happened.
period of time.
Correct, it wasn't.
And the placement, the pre-adoptive placement for this child is the same family that adopted his half-sibling.
Correct. I think the adoption of the sibling took place a couple months before this child was born. So he is, yes, he is with his brother. He's in a kinship home, which would, again.
And they said they were open to visits?
Yes. I think the probability of this kinship placement disrupting was extremely low, if not zero. So to allow them 6 more months at that point, this child's going to be stable in that placement in all likelihood during that time. So there was really no risk to giving her some more time to see where she's at and what she can do. So I would say that this is not a situation of, the faint hope that the case law suggests, where there's no faint hope or some indeterminate period where we're just going to let this case languish. and not know one way or another if mother's going to be in a position to resume custody of her son. Again, we'd have an answer relatively quickly to know where she's at after she leaves the program and if she can continue on the right track. And I think that the courts, before or when issuing her decree, the court made some very helpful comments to Mom about the progress that she's been seeing with Mom and the hard work that Mom has been doing. And I think, it says a lot about where the judge thought she was and where the judge thought Mom was and the work that she had been doing and the progress that she had been making. And just going back quickly to the kinship, in Child's brief, there was a statement that essentially the pre-adoptive parents deserve permanency just as much as the child does. And so I would just suggest that it's not appropriate to look at the pre-adoptive parents' rights, not trying to minimize in any way the care that they have provided for this child, but it's really about the fundamental rights, Mom and the child, and whether Mom is able to parent her son. So I would just end by saying, again, Mom was making progress, not completely where she needed to be yet, but nevertheless, given the progress that she had demonstrated, she is asking that the termination piece of the decree be vacated, just so that there's permanent custody order and the opportunity for a review and redetermination in 6 months, so that she at least has the chance to be able to parent her son in the future. And if the panel has no further questions?
I have one.
Yes.
Can you explain how the judge's use of the phrase substance abuse as opposed to substance use disorder exhibited a bias that infected her decision?
So not necessarily that it infected, but it's just out there as a general proposition that, Mom faced an uphill battle in her treatment from when she first sought treatment years and years and years ago at the beginning.
I understand that. How does the use of that term infect the judge's findings?
I don't think it infects it such that it should
What is it a ground for?
not to vacate her decision based on the use of that term.
And what?
Just pointing out that it's there and it was used.
This wasn't raised at trial.
No, it wasn't. No.
Do you know when these guidelines were adopted by the SJC?
That I don't have off the top of my head.
A month after the findings in this case. So if in the future clinicians adopt some other euphemism for substance abuse or substance use disorder, and substance use disorder falls out of favor, are those going to be grounds in the future for upsetting termination decisions?
No, not the pure use
Not
of the
then
term.
or this one?
Right, not the pure use of the term.
So it wasn't an argument at all?
I'm sorry?
So it wasn't really an appellate argument at all?
No, just pointing out that it was used by the providers as well and the court.
Before they changed the guidelines?
So
they weren't clairvoyant?
No.
Thank you.
Thank you for your advocacy.
Do I understand that you're splitting your time equally, 7.5, 7.5?
Yes, we are.
Great.
Good afternoon, Your Honors. Tracy Corral for the Department of Children and Families. May it please the Court. The Department's asking you to affirm the decree today. I think counsel for the mother as well as the court honed in on the issue here, which is whether or not the court was correct in its finding that mother would likely, that her unfitness was not a temporary condition. Your Honors, I would tell you that the issue here today is not whether we would like to give mother 6 more months or whether you would decide this case differently. The question here today is whether the court abused its discretion by making the determination that mother's unfitness was not a temporary condition. And the Department's position is that it did the court did not abuse its discretion. There were many reasons well documented in the evidence for the court's decision in this case, and I would just like to point to a few of them. As you noted, this child has many needs, and mother has a very extensive history of not following through. And this child is going to require a parent who follows through. It started with the older brother. Mother left when he was approximately 7 months old. In July, I believe, of 21, it would have been July of 2019, I'm sorry. She didn't engage in the care and protection after that. She returned to living on the street and substance use. She did not do any services. She did not participate in trial. And then, of course, as you noted, she was pregnant during the end of that care and protection, and then at the time that that child was adopted, and during that pregnancy with the current child, she did not engage in prenatal care except for when she was involved in the criminal justice system and was referred to BMC while she was incarcerated for a month. She continued to use substances. She did not appear for her appointment for her C-section, even though she had an intrauterine growth restriction. She did not visit with this child. She left immediately after the birth and returned to the streets and using. She did not get engaged in any treatment whatsoever or even in visitation until she was incarcerated, and then it was a condition of probation. So she had an option of going back to jail or engaging in substance use treatment. Substance use treatment is actually the only therapeutic service that she engaged in. The department was asking her to do mental health treatment. Her mental health issues were as prevalent and problematic as her substance abuse issues were. She had quite a lengthy history of mental illness, more than 10 years. She had 3 hospitalizations, involuntary. She also had the numerous times where she had gone to the hospital in the emergency room, been prescribed psychiatric medications, and then did not follow through, did not continue those medications. And she, although she claimed that she was in mental health treatment at the time of trial, she did not know the names of her providers, could not provide those during the testimony, and as you noted, she did not sign the releases. I would also point out to you, Your Honors, that after she returned, she only came to half the visits, prepared for visitation. As you noted, she did not contact the foster parents to obtain information about this child and his conditions and his needs and how he was cared for. And when she was given an opportunity during trial to go to a pediatrician appointment to learn more about her son, she did not do so. She was encouraged to contact the pediatrician during trial twice, I believe, and she did not call the pediatrician. And then with early intervention, she only got in touch with early intervention after being prompted, and I believe the court used the word incentivized in the findings to contact early intervention. She's repeatedly demonstrated not only that her unfitness as to her mental health issues, and I think the court was right to be concerned about relapse and not necessarily, and the court did not believe her when she said that she would not leave treatment when her probation was over. Not only that piece of it, but also this is a child that's going to require so much follow-through. It's going to be a day-to-day struggle with this child. This is a child that at 12 months old was not sitting up, not rolling over, not eating solids. This child's going to need so much care, and this mother has such a long and very well-documented history of not following through, and I think the judge's findings really crystallized that point over and over again as it went through all of the times that she went to the hospital and the emergency room and didn't stay, didn't engage in treatment. It was just demonstrated over and over in those findings, and given that that was there, and so well demonstrated, I don't believe the court abused its discretion when it determined that mother's unfitness was not temporary and that mother would not be able to care for this child going forward into the future. And that is why the department's asking you today to please affirm the decree. Thank you. I rest on my brief.
Counsel?
Good morning, Your Honors. Richard Chokar for the appellee child. May it please the court. The child's asking the court to confirm the orders and decrees of the lower court and free him for adoption. The child argues that, it's in my brief, the adoption of Elena is relatively dispositive of this case, even given, as my sister would say, the positive trajectory of mother's recovery. The judge had no obligation to wait for that to perhaps happen. Mother has, as my other sister has stated, a 15-year history of mental health issues that are untreated, substance abuse issues, incarceration, criminal history. She went AMA at the hospital. She only really resurfaced after her arrest and her placement at Granada House, which was a condition of her release.
I want to ask you something. It is outside
Sure.
the record, so if you could just give me a yes or no. Is
Sure.
the child's health improving?
I'm sorry?
Is the child's health improving?
Yes, Your Honor. Yes. And since we're not really challenging unfitness, Catherine really just shows us it's two sides of the same coin. To what degree mother is unfit determines the best interest of the child. And given her non-engagement and the thoroughness of the 210 plan that the judge considered, the kinship placement, their apt abilities with the child to help improve, and as you pointed out earlier, his placement with his half-brother, who he's quite bonded with, there's no reason to disturb the judge's findings. So if you have no other questions, I rest on my brief.
I don't see any. Thank you very much. These are very difficult cases. The case is under advisement. Thank you all.
Thank you, Your Honor.
The final case we'll be hearing today is a paired case. It's ZHENG versus SHEN, two docket numbers, 23P1468 and 24P295. They've been paired for argument. Each side is permitted 20 minutes. There is no rebuttal.
Your Honor, I believe it's the appellant to proceed first.
You are the appellant. You need to stand in front of the microphone so we can hear you.
Yeah. Your Honor, may I please the court, this is Jay Tan representing the husband to the appellant to this case. These two cases both are relating with the judgment, content judgment. The first one is the husband filed complaint for contempt on April 23, yeah. So that's this, in this judgment, the judge did not find contempt against the wife. So I'm just going through, there are several factual errors that the judge.
Can I just ask you, I really don't understand your judicial estoppel argument, because the wife took a position during the pendency of the case, and the judge entered a judgment that was different than the position she took during the pendency of the case. So what? That happens all the time. People argue for things in temporary orders, judges do different things, or sometimes the parties change their mind. I don't understand your judicial estoppel argument at all.
Well, the wife first swore to court that she
wanted to keep it, she was going to be able to refinance it, she was going to pay him out. I get that, but that's not judicial estoppel.
She paid all the down payment. That's how the
It's not judicial
litigation.
estoppel.
So the court asked her to retain the entire title of the house. Order granted that her request. And then she just flipped her position, saying, oh, now I don't want to retain the title anymore.
So how is that judicial estoppel? What is your best legal case that you can cite to me to support your contention that that's estoppel?
She obtained.
No, I want a case from the books. Give me a case that says that that's estoppel.
Well, Your Honor, I don't want to argue that estoppel at this moment. I just want to point out that.
Are you waiving your estoppel claim?
I'm not. Right now, it's up to the court to take a look at that.
Your first argument is that the plaintiff is barred by a judicial estoppel. I'm asking you for case law to support that. You tell me that you don't want to talk about that. So
there's a lot of federal cases, like in state of New Hampshire versus state of Maine, where the Supreme Court says from the parties are prohibited from deliberating charging positions according to exigency.
That case is not cited in your brief. So where are you getting that case from?
Yeah, that's a Supreme Court case, United States.
Okay.
And there's also the First Circuit case that says when the parties deliberately dishonesty, serious prejudice to the judicial proceeding or the position of the opposing party, which is the Desjardins versus Verban Community Hospital, the First Circuit case, 1994. And, but anyway, there's a lot of errors that first the judge says the wife doesn't have to deliver the deed because even though the order asked both parties to ask the property to be sold upon sale, the wife has to, the husband has to be paid from that. But there is a case, even though the court should interpret this order a little bit, it does not discharge the wife's obligation from the order that the house has to be sold. But the judge says there's no clear order as requiring the wife to deliver the deed. If the wife refused to deliver the deed, how the court order of the upon sale of the house to be complied with. So even under Stabile versus Stabile, 55 Mass, this decided by this court 2002, and also Wooters versus Wooters, decided by this court, that it's the totality of the circumstances to...
What do we do with the judge's findings that it was the husband who prevented the sale from happening by adding the conditions that no disbursement shall be made at closing time?
The husband, I personally communicated to the buyer's attorney of those saying that it should not do, but the buyer's attorney did not respond. So that's just I proposing to the buyer's attorney. It's not binding, it's not a term, it's not in any agreement, and we delivered the deed this power attorney was void, was never delivered to the buyer's attorney. It was just delivered to the wife's real estate attorney. So on April 26th, we delivered the entire package because even though this buyer attorney did not respond to me about my proposal, not dispersing anything, my side, my client's side, the husband's side, delivered the entire closing documents and the buyer's attorney extended the closing date on from April 26th to April 27th. So on April 27th, there is clear documented in my brief. I also, and in the appendix, that the wife's real estate attorney sent an email to the buyer's attorney saying, no, we're not going to release the deed. Then they canceled the sale. They canceled the entire sale. And not only that, they removed the listing of the house from the market. So that's entirely under the order. And the divorce judge also ordered the wife to retain the title of the entire title of the house. She did not intend to do that. She elected to sell the house before March 15. And there was no evidence supporting her that she was not unable to pay the husband.
What if she just changed her mind and decided, you know what, I don't want to own the house, I'm going to sell it?
Well, the judge ordered her to retain it because she wanted it. She could not sell it.
Either or, right? You can either keep it and pay him out, or if you don't, by a certain date, you have to sell it. I don't read that as saying the judge is forcing her to own the home until the potential sale date. I don't know where you get that
Well,
from.
the wife shall retain in all, so that's a shall, right?
Or.
No, it did not say or. The wife shall retain in all title. Okay, that's the first order.
Right.
And the second order, the wife shall pay the husband certain money, okay? So the third order is in case the wife could not pay. It's not saying the wife has any kind of circumstances that she could sell the house. It says in case the wife could not pay, the house should be placed in the market. I think the order is very clear that she could not elect to sell the house unless she can show that she couldn't pay. There's no evidence that she couldn't pay. And she didn't close the fourth order is she should close the business account. She didn't close. There's no evidence she closed it. After 2 months after we filed a complaint for contempt, she mailed a personal check, which doesn't show anything about the business account, whether it's closed, how much should it be, what is the final balance. And the judge says, okay, that's fine. She doesn't have to follow the orders because she paid a certain amount. But how do we know whether that's the amount that's supposed to be that amount, whether the business account was closed or not? So the judge is finding that the husband caused the non-sale of the house. That's nonsense, because the husband delivered every little document to the buyer's attorney, and the wife's attorney says we're not going to release the deed, and we're going to take off the house from the market. and until 6 months later, okay? So what if the judge's order doesn't have any force? If she doesn't have to follow any orders, why does the judge make an order? Who gave her the right? Who gave her the right to take the house off the market? And she's not paying the husband anything. 1 single month, she's not paid anything. And basically, the husband's equity has been a 0% interest loan to her. And she and her 2 adult children lived in that house for no rent to the husband at all. She and her 2 adult children evicted the husband. They filed a false complaint restraining order, actually. There's a long story, but that's what it's like, that's the case. And during the trial, the judge, first of all, refused to allow the hearing, allow the husband to testify.
We're not here for the divorce trial. You talking about the divorce or the contempt?
The contempt, I'm just saying, this $85,000, this equity.
Counsel, are you saying the husband was not allowed to testify at the contempt trial?
No, I'm sorry, Judge.
Okay,
I'm saying the husband was not allowed to testify at the divorce trial.
And that's not before us, so let's stick with the contempt.
Yeah, but the judge affirmed this in her order, the 85,309 divorce fee that should be subject to abuse of discretion. She did not say why she affirmed that. She did not say whether it's prejudice. It would carry a prejudice against the husband. She did not consider any of the weighing factors. Basically, she refused to hear any evidence. I think this refusal of hearing evidence should be subject to discretion.
Not raised in your brief either, so we can't consider that. You raised 5 issues in your brief, so we should stick with those.
Okay,
Yes,
Your Honor.
what I don't understand is if the husband had not put these limits on the closing by saying the funds can't be dispersed, he'd have that 85,309, wouldn't he?
But the husband did not agree to the 85,309, we're entitled to tell that to the buyer attorney. The buyer attorney can do anything. He can decide, or he can sort for the court to clarify on that. But we are entitled to tell the buyer's attorney what we think about the 85,309 was.
Even though the judge said the number is 85,309, the husband
the
gets
buyer
to overrule
attorney,
the judge?
Well, the buyer attorney could do anything on that. Even the judge did not forbidden us not to tell the buyer attorney about anything.
So isn't it your client that blew up the deal?
Excuse
By
me?
adding that, right? Your client decides to tell the buyers, yeah, there's a dispute over the money, we're in court about this. If I'm the buyer, I'm running from this deal. Isn't it your client that put in process why this deal fell apart?
No, the buyer attorney extended the closing date to the next day. So it was not falling apart until after the wife's attorney told the buyer's attorney that we're not releasing deed. We actually, I told the buyer's attorney several days, 1 week before the closing, but the buyer's attorney still prepared all the documents. It's not the husband's position caused the, that's what the court says, that the judge said, but that's not the case. I actually communicated to the buyer's attorney 1 week, maybe 2 weeks before the closing. And the buyer's attorney still prepared all the documents. And we delivered the entire package to the buyer's attorney, but the buyer canceled the deal after the wife's attorney refused to deliver the deed on April 27th. We provided documents. We provided, say, the buyer's attorney received all the documents and they were happy, they were ready to close, they calculated the closing amount, all of those things. So the judge was wrong, but the judge did not make a finding in the judgment that the wife refused to deliver the deed. She just made the conclusion, says the order does not require her to do that. But if the wife refused to deliver the deed, how the sale was going to sell? The judge did order the house be sold.
I have a question for you about your brief. This is at page 43. It says, as a result, defendant and his counsel have suffered dramatic emotional distress over the long and painful struggle for equal protection. And then the brief asks for attorney's fees for the husband. Is it your understanding that dramatic emotional distress suffered by a lawyer is grounds for the opposing party to pay attorney's fees?
Not really, but so we can just ask for those things. I did suffer dearly, and from the entire trial, that the divorce trial, the judge made prejudice decisions against me and my client again, refusal to hear our evidence, refusal my client to testify, refusal violate my client's due process rights, refusal to continue the case, refusal to update the appraisal, and refusal to grant continuation of the case. Admit hearsay evidence of the wife.
We're going to have to leave it there. Your time has expired. We have these arguments, the ones relevant to the contempt in your brief. Thank you.
Thank you, Your Honor. I have not talked about the second case yet.
This was the entirety of your presentation. You had 20 minutes.
So I just want to say the
Counsel,
second.
your time has expired. We will take the rest of your arguments on your brief. Please have a seat.
Okay, so I will go ahead.
Counsel, you have 20 minutes for both cases.
Thank you, Your Honor. May it please the Court, Chief Justice, Justice Meade, and Justice Grant. Catherine Birwas on behalf of CONGHUI ZHENG, the wife in this matter. On the first appeal, where CONGHUI was found not in contempt, neither party actually was found not in contempt when there was a hearing. There were competing contempts.
You didn't appeal the not guilty finding against the husband?
We did not,
Okay.
no. The judge's rationale was solid, it wasn't clear and convincing, and therefore we had no grounds to appeal.
I have one question.
Sure.
You don't cite Burchell, which is the current standard for contempt. you cite some older standards. You would agree that Birchall is the governing standard, like your sister cited?
Yes.
Okay.
Your Honor, counsel spent a lot of time on the fact that her client was not responsible for the failure of the sale to go through, and that caused my client not to be able to sell the house. I would refer Your Honors to pages 61 through 65 of the record appendix, and I will just highlight on page 71, counsel told Attorney Shepard, who was the closing agent, that all proceeds needed to go into escrow. He further told her that she cannot unilaterally control the closing, and that if there wasn't a court order, that he had to, he basically had to follow a court order. They did move the closing from April 27th, from the 26th to the 27th, in order to allow the closing to occur, in hopes that they would receive a deed and documents that did not require additional language. And that happened on October 26th at page 68. Attorney Tan said that she attached documents. She said the sale proceeds shall not be distributed to the sellers other than paying off the fees associated with the closing. Again, Attorney Shepard said, see my prior email, Attorney Tan is unilaterally trying to change the divorce decree. I do not believe Attorney Hong has agreed, and there is no authority to release the ex-wife's deed unless the proceeds are released in accordance with the court order, as in the court's judgment.
So she essentially wanted all of the proceeds to be held in escrow?
Correct.
And the judgment just said he was getting $85,309, and presumably after closing costs and whatnot, the balance was going to go to your client.
That's what the order said. The remainder would go to my client.
So the language on the judgment is somewhat interesting, because it doesn't really say, it doesn't say she can sell it early, necessarily. I want to read you. It says that in the event she's unable to make the payment by March 15th, the property shall be listed by a mutually agreeable realtor, and that he gets $85,309. So is there a precondition that she has to show that she can't make the required payment? And if so, what evidence do we have about her inability to make the payment? Or could she simply just change her mind and say, I want out of the house, I'm going to sell it?
I think that the climate of interest rates between the time of the divorce, and this was just the end of COVID, things were completely different than they were, initially when she thought that she was when she wanted to stay in the home. And I think the fact that she didn't wait until March 15th and not pay him when she knew that she wasn't going to be able to, that she then put the house on the market the month before. The husband signed the listing agreement. He signed the purchase and sale agreement. Everything was moving forward. He was going to get his money. He would have had his money on April 26th.
And what stopped everything was the insertion of this language about putting everything except the closing cost in escrow, essentially.
Correct, Your Honor. And a copy of the deed is at SRA 52 of mine. And at the bottom of the deed, there's an asterisk that says, on the deed itself, the disbursement of the proceeds shall solely comprise paying off mortgage and broker fee and taxes and other necessary fee adjustment for closing. No disbursement shall be made to CONGHUI ZHENG or LIANG SHEN at closing time. Now, if she had complied with that, she actually would have been in contempt, because at the time of the closing, she had to disperse the $85,303 to him. One of the emails between Attorney Tan, I'm sorry.
SRA 52 is signed by the husband and notarized by Attorney Tan.
That is correct.
And who was this given to?
This was given to the buyer's attorney. Attorney Tan, during the argument for the contempt, said that she had agreed that both parties could take out $85,000 and just put the rest in escrow. That was, I don't believe that was an accurate statement. None of the emails between the parties, between any of the attorneys, makes any sort of concession. As a matter of fact, at page RA 67, Attorney Tan says, the court did not order the disbursement to the wife to be made at the time of closing, just to the husband. So I think that that was disingenuous at best. She made claims of fraud in the emails.
Regarding the stipulation of value?
Yes, and she has made claims of fraud throughout. She's claimed.
What do you say to the husband's counsel's argument that, well, the buyers could have just disobeyed this statement in the...
I think that there wasn't I don't know of an attorney that would have disregarded a clause typed onto a deed, signed and notarized, and put themselves at risk by doing something contrary to what is being presented by the attorneys. I can't imagine any attorney wanting to put themselves at risk for a closing.
Can I ask you about the business account? You make the argument at page 17 of your brief that it was paid before the hearing, but is it true that it was not paid until after the husband filed the complaint and the wife was served with it?
That is true. It was
Doesn't that still constitute contempt?
It was $338. The account was closed, but the payment wasn't made. And
But if the purpose of contempt is coercive, to make somebody do something, and he files and serves it, and then she pays it, whether it's $1 or $1 million, isn't that still contempt?
the judge didn't find that, but I do have to concede that that is a, that would be a not finding, that would be a finding. If you could read the language, I believe, of the order says that she shall close the account within 30 days and then give him a check. So if you parse it out, she did close the account within 30 days, she just didn't give him a check, which, by the way, in the record includes her name, address, phone number, and account number, without it being redacted. So I would say that she did close the account within 30 days, and not having been the prior counsel, when I asked if she had given him the check, she wrote the check and sent it to him.
It does say she'll close it in 30 days and shall transfer, but there's not a date.
Right. And considering the, Judge Doyle found that he was not in contempt initially because he was not compelled to sign the sale documents, he was only compelled to sign the loan documents. I think it would also, the same could be said for that. It was not, if she was going to parse one, it would be equal on both sides.
So if you could just answer this yes or no, because it is outside the record. Has the house been sold?
No.
Okay. Tell us why you're entitled to fees.
I'm sorry?
Tell us why you're entitled to fees.
So counsel seeks to relitigate this divorce at every turn. Everything that she's presented, the hundreds of pages of the record appendix were dedicated to contempt, pre-divorce judgment. And We've had to respond to things that are irrelevant. She has had no reasonable expectation of reversal. The appeals are frivolous, they're immaterial, and intended to delay. It just intended to punish, to try and, the only thing I can think is to browbeat us down to when we finally will agree to something more than the $85,000. Now, the law is settled on contempts, and there is no real issue. He was found in contempt. The judge gave him multiple opportunities to comply. She ordered in her September 28th decision, she was very clear. She laid it all out so that this house could get sold. And what does he do? He gets the listing agreement on October 10th, doesn't sign it. By October 16th, I'm reaching out to counsel saying, is he going to sign it? Like, if you don't sign it, we're going to file a contempt. And so she said she's reviewing it. She wants to negotiate. These are negotiations. There was no negotiation. The judge's September 28th order said, use the same broker and move forward to get the property sold. This was the exact same contract. The only difference was the date for what he signed in January.
Well, she also said to follow all recommendations of the Realtor, and there was some quibbling about the listing price, right?
Yes, Your Honor, but the only one that actually gets harmed by a lower listing price is my client, because her client still gets his $85,000.
His number is static, no matter what.
Right. And so the fact that he was holding it up, we had to go, so he finally signs the listing agreement. We get the purchase and sale. A couple weeks later, we get a full price offer for a purchase and sale. And he adds in language to try and frustrate that sale. And we went back to the judge. We're like, this needs to be signed. This needs to be signed now. And I think it was, so we were there in November, we were there, and the hearing was continued to December. So those November and December transcripts were not included. Why are we asking for fees? Those November, December transcripts, which were part of the ultimate finding of contempt, were not submitted by the appellant when they filed their contempt. They only submitted the January 4th transcript. So the supplemental record appendix includes those two. Judge Sua Sponte at, I think it's 93, SRA 93, issued a Sua Sponte order outlining what hearings there were and when they were and what related to the ultimate finding of contempt against Mr. Shen, and that was included.
And where is what he, can you just, the record is huge. Where is it what he tried to insert the second time?
I have it.
It's in the P&S, right?
Yep, I pulled the page. Sorry, Your Honors, I pride myself in knowing everything in the record, and I have it pulled out. I have it. It's on RA 317. May I read it? The sales price was ordered by Berkshire Probate Court in the second contempt hearing based on its judgment on seller Ho-Lang Shen's complaint for contempt. And seller Ho-Lang Shen has appealed the court's judgment on his complaint for contempt. Whether the judgment on his complaint of contempt by the Berkshire Probate Court is valid or not may take many months to be determined by the appeals court. The appeals docket 2023 P 1468. Please consult with your attorney. I can't imagine why other than to frustrate the sale, especially in the original divorce decree. CONGHUI ZHENG has to hold the husband harmless for the sale and the property. So there's no other reason than to frustrate the sale. Okay. Back. So, Your Honor, Your Honors, I'm sorry. The other reason we're asking for attorney's fees, and we're asking for them not only against the Mr. Shen, but also against Attorney Tan, because of the disrespectful, irrelevant passages and allegations that are totally without support in the record. She repeatedly uses fraud, that there's been a fraud on the court, a fraud, that we're perpetrating fraud. She's included in her brief that we fabricated the purchase and sale agreement for the January 5th purchase and sale agreement, that we fabricated it in some way. And she's routinely calling myself and Attorney Roldson Miller, my associate, liars in court, in paperwork, constantly. And by repeatedly allegations to relitigate the divorce finding. I mean, that is a done deal. It has been. The case was decided. She filed the Rule 59. That was denied. She appealed. We had to defend the appeal. This court affirmed it. She filed a reconsideration in which she included a complaint that she filed with her judicial conduct against Judge Decision. I don't know if that was a veiled threat or what, but that was included in the reconsideration. And again, this court denied it, the reconsideration. She filed for further appellate review. That too was denied. The first appeal that my client is...
Those are not before us, right? We have two things before us. The first round of contempt, if you will, where everyone was found not guilty, and then the second round of contempt where the husband was found guilty with respect to the deed and all, okay.
Yes. With respect to the purchase and sales and listing agreements. The deed was in the first one. So the first appeal, but we had to defend all of that, and that's part of why I'm saying attorney's fees are relevant, because we've gone through all of that. And she comes back again and now says, we've got the first appeal that that my client was not in contempt. We have the second appeal when her client was found in contempt, not including the two transcripts that were continuations and noted by Judge Doyle's sua sponte order that were related.
On a civil appeal, they don't have to file a transcript if they don't want to. I mean, it hinders our ability to do our job, but they're not required to.
Okay.
Right?
I will take your word for it, Your Honor. I apologize. I did believe that they needed to all be included. Most of the appeals.
Better practice, if you want us to review something, is to give us everything.
I would think so. Yeah.
That is appealed, but they're not required.
Okay.
Unfortunately, parties don't file transcripts a lot.
It's different in New Jersey, so I apologize. So everything that she's done has been trying to overturn the divorce decree, and it's a continuous battle. So, Your Honors, we would ask that you affirm CONGHUI was not in contempt, that Mr. Shen is in contempt. The determination that the appeal is frivolous is left to the sound discretion of this appeals court, and we ask you to find that both appeals were frivolous and intended to delay, and that both Attorney Tan and her client are responsible for the fees and costs. Thank you for your time.
Thank you. The matter is now under advisement. This concludes today's session of the Appeals Court. I'd like to thank our court staff, in particular our court officers, our wonderful timekeeper, and our law clerks. We are in recess. Thank you all.